So far, we've spent our time examining what the concept of equity is within the general perspective of equity and trust law. This lesson is going to now move on to the next of these elements, which is, of course, the element of the trust itself. Now, in this lesson, we're going to talk about what a trust actually is. And you'll be surprised to know just how many undergraduate law students go into their Law of Trusts first lecture, or maybe their first tutorial, and they do not know what a trust is. So this may be helpful to those of you who are just about to start the Law of Trusts, or for those of you who want to get ahead before you study the Law of Trusts. So that's what this question is going to this lesson is essentially going to answer the question: what is a trust? What do we mean when we call something a trust? Like I've said, we're moving on away from the study of equity to the subject of the trust. And in fact, the rest of this series is now going to focus on the study of the trust. We're going to talk about the private express trust, we'll talk about the three certainties, the formalities of a trust, the constitution of a trust, charitable trust, etc., 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 etc. We'll examine essentially what a trust is in this lesson, as well as the main considerations for the establishment of a trust, and also the various different parties who are involved in the creation of a trust. The purpose here is for essentially me to go on for the rest of these lessons explaining the various different people and the different titles that exist within a trust relationship, and not have to constantly have to essentially define who these people are. So if I say trustee, you'll know exactly who a trustee is, or a settlor, or a testator, or a beneficiary, for example. So ultimately, the trust is not something which has been particularly very easy to define. We'll get to this in the next lesson when we look at some of the essential elements of a trust itself, because ultimately, owing to the wide variety of different kinds of trusts that exist, as well as the various different purposes for which an individual may establish a trust, it is very difficult to define what a trust actually is. But we can come to some kind of definition, okay? As mentioned previously in previous lessons, the concept of the trust is something which is an invention of the law of equity. It comes out of the concept of equity within the development of the common law. And it was an invention in around the 18th century where, for the most part, landowners would essentially create some kind of protection for the benefit of their future families, some kind of protection of that land for the benefit of future families. And it's from here that we can get to some kind of definition of what a trust ultimately is. Now, a trust is essentially a relationship in law whereby the holder or the owner of some property will be able to transfer the legal title, transfer that ownership to another individual, but not in the sense that they are transferring it because they want to give it to them as a gift, but for that individual to hold said property for the purpose of benefiting a third party, another individual. And that's what a trust is. You're holding property on trust for the benefit of some individual, okay? Now, this property in question, we will get to what the certainty of subject matter actually relates, but it can be a variety of different things. It can be property in the case of land. It could be property in the case of private ownership of property. It could be money. It could be some kind of fund, for example. All of which can constitute the property itself, for which the legal title is being transferred to a trustee for the benefit of some kind of beneficiary. And with that being said, let's think about who the individuals are within a trust relationship. Okay, there are multiple individuals. The person who is the original owner of the legal title, who is going to send that title to another individual, is known as the settlor or the testator. They are the settlor if they are creating the trust before they die. If this is a trust which is created after their death, if it is created post-mortem, for example, then they are known as the testator of that particular property. So if ever I'm talking about the creation of trusts, the settlement of trust properties, and I'm talking about the relationship or the role that is played by a settlor or a testator, you know that that is the individual who is the original owner of the legal title, who is transferring that legal title to another individual, and in doing so creating a trust. The individual who is given this legal title and is told to hold this property on trust for another individual is known as the trustee. Okay, the trustee is the person who is essentially the individual who is responsible for that trust. Whether that may be responsible in the sense that all they have to do is hold on to that property, or they may have even more powers to essentially distribute the property as they see fit in the case of, for example, a discretionary trust. They are the trustee. That is essentially their role. The person who benefits from the trust is called the beneficiary. They benefit from the trust. Okay, so this is what essentially the trust is established for. And that's how we see the relationship of each individual within a trust. We have a settlor or a testator who transfers legal title to the trustee, who then holds that property for the benefit of the beneficiary. This is the relationship of a trust system itself. These are the individuals who exist within a trust. Now, in terms of legal and equitable ownership, the settlor and the testator, or the testator, has the original legal title. They transfer that legal title to the trustee, but the trustee has to hold that property on trust for the beneficiary, and therefore the beneficiary has equitable rights to that property. So they have rights in equity. And what this essentially does is split what is legal and equitable interests in the same property, because ultimately the trustee holds the legal title of that property and the beneficiary will hold the equitable title or equitable rights in that property. And so what a settlor or a testator is doing in creating a trust instrument is dividing the legal and equitable rights over a piece of property between a trustee and a beneficiary. Now, we're going to talk in a little bit more detail about defining trusts in the next lesson, talk about some more of the characteristics of a trust, but we'll also then start to talk about the various different kinds of trusts that exist, whether they be implied resulting trusts, constructive trusts, discretionary trusts, for example, and then we will then, from there, start to talk about the first of our trusts that we're going to explore in more detail, which of course is the private express trusts and the formalities that are required to establish them.